Yes, I
When
think I'm on mute. Yes.
And are we streaming now? Do you know if we're good to go streaming, etc.?
And board member Haynes just joined us. Okay.
I'm sorry. Jerry said yes.
Jerry said yes, and I'm recording.
Perfect. Okay. Welcome to the October 2nd, 2020, this extraordinary year online law and licensing committee meeting. Welcome board members and welcome those of the public and other education partners and collaborators who have joined us and all the staff members. Thank you for your time. We'll begin. I always like to hear the actual voice of the board members who are also participating with me, so I can see their names, but I think the public might like to know that they're not disembodied voices. So if board members would introduce themselves, maybe starting with Vice Chair Cummins.
Yes, sorry, I can't
That's all right.
I can't find my camera button to disembody myself or embody myself. Sorry.
I will stop my video. Yeah.
Oh, there's the camera video. I have a body. Okay. I'm Brittany Cummins, District 6, Law and Licensing Committee. It's good to be here.
Thank you. Thank you. Cindy?
Cindy Davis, District 9. Nice to see all of you today.
Lorianne?
Lorianne Thorpe, District 3. Happy to be here.
Thank you. Mike?
Hello, everyone. Mike Haynes, District 11. Great to be here. Thank you.
I think that's everyone, right? Did I skip somebody? No, that's good. And my name's Carol Lear, and I'm in District 7, and I'm the chair of this committee with great assistance from numbers of USBE staff members, primarily Angie Stallings, and also Vice Chair Cindy Davis. So with that, we'll get right into the meeting. And we have item number 2.1, which is the United Way West Ed request for de-identified student level data. And it looks like our primary presenter is Whitney Phillips with a number of helpers. And Whitney, I'd ask you to introduce them to the extent they are participating. Thanks.
Sure. Good morning, Whitney Phillips, Chief Privacy Officer. We actually have agreements with United Way and West Ed, but we do not have an agreement for this purpose. They're looking into student mobility, and actually a number of folks wanted to speak on this. We have someone from West Ed named Dr. Hahn, and also recently we also have Tracy Gruber, who is also interested in this. I wasn't sure if you had any questions for them or if you wanted them to speak about this request.
Why don't you named the request, but could you tell us a little bit more about it? And if they can help you, that's great. We don't necessarily need additional information unless board members have questions, and that'll come right after you give us a little more information about the agreement. Is that okay, Whitney?
Sure. I think I'll pass it on to Dr. Hahn, who works with, not Dr. Hahn, Tracy Gruber, who knows about this data sharing agreement a little more. Tracy,
Perfect.
Are you okay with talking about that?
Well, I'm happy to kick it off. Can you hear me? Yes.
Yes, perfect.
I actually am not the primary requester of the data. I'll just share very, very briefly on why the Department of Workforce Services is interested in this data request and supports this data request as it relates to the Intergenerational Poverty Initiative, which I've talked to before with the State Board of Education. and USBE is represented on the Intergenerational Welfare Reform Commission by Superintendent Dixon. This is an initiative to measurably reduce intergenerational poverty among Utah children, and we look at the data of child mobility through workforce services data and changes of addresses, given both the relationship of mobility for child emotional well-being as well as academic outcomes, and is an indicator for overall economic stability in a family. So we do have some data on mobility as it's reported to us by families accessing services in the Department of Workforce Services, but we do not have data that is being requested by WestEd and the United Way that really reflects student mobility from one school to the next. So that's our interest in it, and I'm happy to answer any questions on how this particular factor comes into play in the Intergenerational Poverty Initiative. But in terms of the specifics on the data request, I would defer time to either Ken Wynn or Amy Terpstra or Dr. Hahn.
And so Whitney, I'll let you just continue if you think other people need to add, and let me know when you think we have enough information, and then we'll see if any committee members have questions.
Well, I think it's wise to listen to Kenwyn Derby and have her speak to the specifics of the data analysis.
Sure. So I work for WestEd, which is a nonprofit that's been supporting USBE for decades now. We are part of supporting the Promise Partnership regional initiative that is facilitated by the United Way of Salt Lake. And that includes many dozens of cross-sector partners, including 6 school districts, USBE, many governmental agencies at the state, county, and municipal levels, nonprofits, and businesses. So this is really in support of this broader initiative, which is to improve outcomes for students. And Amy Terpstra is the Vice President of Collective Impact for the United Way of Salt Lake, and she's here too if you have more questions about that broader work. And the request came out of a couple different work groups that are focused on improving outcomes for students and families. And one thing we do know from research, both locally and nationally, is that student mobility is a risk factor in student academic performance, graduation rates, and lots of other familial and student outcomes. So we wanted to really better understand the needs and the context in the state of Utah, and specifically in these 6 school districts. But the data that each district has is only, they have access to their own data. But to look at mobility across districts, we need the data from the state. And what this would help us see is not just mobility rates school-wide and district-wide, which are already published by USBE, but we could see individual moves. So where are there many moves? Where are children moving from and to? Are there hotspots in certain neighborhoods, or hotspots that are shared by a few districts that could work together to intervene with those families and students that are seeing a lot of mobility? So there's kind of 2 sides of that. There are some schools that have high mobility rates, but then there's also students and families who have high mobility rates. So a student might move schools 3 times in a year or 6 times from K-12. And we know that that really puts them at a disadvantage. So we're trying to uncover and map these rates of mobility so that we can then more efficiently and more effectively bring communities together, nonprofit agencies, United Way, districts to work together to try to mitigate these effects of mobility, and maybe even step back further, like with the Intergenerational Poverty Commission, and say, how can we help families stop moving so frequently? If they do move, how can schools and their community partners support those students and families so that these moves don't put them at such a disadvantage that we see now? And I could talk about lots of the other things we could analyze, but that's the main point.
That's helpful. Thank you. Is there someone else we should hear from, Whitney, or do you think we should go to questions? Or can we? go to questions. May we?
Unless anyone wants to add anything, I think you have a good picture of the data request.
Thank you. So do board members or committee members, I'm sorry, who are also board members have questions? And I can actually see hands, I think, or you can also. Lorianne, do you have a question?
I do, thanks. I'm interested, several of you know that my background is in, I have an interest in children in foster care and educational outcomes for them. So I'm very curious. Of course, we know that children in foster care have high mobility rates in schools. So I'm hoping that this data will help track some of that. That's a very specific group, but I think but the mobility is such an important factor in their educational success. So will that inform that work?
Please, anyone else on our team jump in if I'm leaving something out. We have not requested data indicating whether or not a student is in foster care or not. However, I am aligned with you. I was a court-appointed special advocate, and I've been working with foster students who are in foster care through First Star Academy at the U. So I really am happy to hear that. So we did not ask for those data because for lots of reasons, including sensitivity and privacy. But what we could do is combine the information that we learned from these analyses with what districts and schools know about their foster student populations and kind of work together to figure out where we can provide where we as a whole state and community can provide additional supports for foster students. The data are really clear that foster students are at a disadvantage. I'm not sure what more we can know except if we actually looked at specific schools that they're transferring among. So we're not asking for those data, but I think it would help us infer more information.
Thank you. Lorianne, does that sort of get you?
Yeah, can I ask a follow-up, Carol?
Oh, please, yes.
Yeah, I'm just curious. So I would love to see some, let's work on this together because I would love to see, anecdotally, I think we understand that kids in foster care have high mobility rates. We can see that, we can track that. But I think it would be really interesting to figure out with this data project if there's a way to connect some data and see if we can make a case about how to impact the mobility. So I'd love to talk with you offline of this about how we could do that.
Thank you.
Happy to receive those data. If you would like to provide those, we can add that into the analyses. We just hadn't put that in our request.
Thank you. Other committee member questions? I have one, but I'll wait until it's not very complicated. I don't see any other hands raised. And if you think you're raising your hand and I'm not seeing you, please just
Carol, could I ask just one more question?
Of course.
It's also making me think about what we talked about in the board meeting yesterday about military families. And I'm curious if we'll be able to extrapolate anything about military families and mobility there. I'm thinking maybe in military families, we're talking about moves outside of state. So it might not quite play into this, but I'm just interested in hearing more about that too.
Thank you. Thanks. My question, and maybe for Kenwin, probably sounds like, is if you will be able to distinguish in your data gathering between families that are students and families that are choosing to change schools versus those who are forced to change schools. Mm-hmm. Because I've been surprised recently how much more mobility there is in just the regular student population among all students than there ever was, even than there used to be 2 or 3 years ago. And so I wonder if your data will distinguish between those who are choosing to move for choice reasons or versus those who are forced or even pushed?
That is a really great question. And I also just want to acknowledge that Jenny Earl, board member Earl, put a comment in the chat, so I can answer that question after as well.
Oh, good.
But board member Lear, there is research in the world, so in America, but not in Utah, about the difference between optional moves, so families who are choosing to move, and oftentimes even are moving to more affluent neighborhoods or more higher performing schools, that those students do suffer less from mobility, right? So if you're moving because of a forced move, you tend to suffer more academically than the families who choose. This analysis will not be able to look at that. We have no way of knowing that, but it's a super question, and actually one that the Promise Partnership work group that this came out of, led by the United Way, and includes Tracy Gruber from Department of Workforce Services. We are all working together to come at that question from two different sides. Let's try to reduce forced family moves through support of renters, through sharing of information, through lots of different community-based efforts and legislation around helping families avoid moving if they don't want to. And then this other side is saying, okay, when kids are moving, who are they and what happens to them and how can we support them? So some of the data that we would also be collecting or receiving from you includes some demographic information where we could do some correlations and say, you know, the students who are not in the low income category are not actually, maybe we'll see that they don't move as much, and maybe we'll see other relationships in their outcomes, but this is really simple, just who, where, when are kids moving? So that's more of a question, like if somebody wanted to do a community survey or a different sort of study. It's a good
Great. I just looked also at board member Earl's questions, and having just been an intervener in a previous committee meeting where they were very generous to give me some time, I'd rather just have Jenny Earl ask her questions herself, if that's okay with other committee members.
I think that's a great idea. Thank you, Chair.
Okay, go ahead. Member Earl, I think you can just unmute yourself and speak.
Okay, thank you. Thanks, Carol. I appreciate that. I just have a couple questions on this one. There were some spots that were not filled out. They were the yellow indicators. Is it just because it's included down below, or it's just not completed yet?
I'm not sure about that. We submitted a completed version that had all of those yellow highlighted questions filled out. I had assumed it was redacted for this public posting or something.
Okay. I don't know. I was just looking at information.
I can answer that.
Why.
Okay.
I can answer that. It is because a lot of the information is below, and it was hard to kind of fit into the space that we provided.
I just wanted to make sure. So.
Okay. All right.
Okay. And then
go ahead, Jenny.
Go ahead.
No.
Then the other two questions: which children specifically will you be collecting data on? Is it Title I schools? Is it just in Salt Lake County? Is it who are we talking about? Or is there a trigger thing that says this child, because they met this criteria, or they moved out of school, that we're going to, who's the data?
Gotcha. We are not collecting data. We are receiving data that USB has already collected, and it is on all students. So we're trying to.
So you're taking all the children in Utah. We are giving you their data, all their personal information.
De-identified data on all students. Yeah, and your other question about will other people have access to the data? No partners have access to the data because of, yes, so this would be a direct, secure file transfer just to WestEd, where we would store it in a secure location, and we would destroy the data as soon as this study is completed. The United Way has an existing umbrella agreement with USBE where they receive data. We are not sharing these data between us because of FERPA. We're following the letter and the spirit of FERPA, where we would not share data even though they have their own agreement with you. So this would be de-identified data at a student level of all students in Utah. And the focus originally is the districts in the Promise Partnership, the 6 districts. But we also know that there are many other districts that are contiguous to those, And if we can also provide some bar charts and other sorts of data visualizations to show you some patterns across all districts, we think that would be really helpful for educators.
Then I just have one other question. So what workforce services, what will they have access to that same, I know the end results, but the data that's sent to you? Okay.
No. So they're here in support of the idea of this analysis. They get different mobility data and they can't analyze down to the student level. They look at family mobility. And so as part of this cross-sector group that's saying, hey, we all want to work together to support students and families, they don't have the data to answer this question. So, and they will not receive these data. So the only thing that we will share with others outside of our small data team, including Min Huang, who is joining me here, are the completed analyses. So the output, the aggregated data and visualizations.
Okay, thank you.
Thanks. Thank you very much, Jenny. And I appreciated that de-identified word that came from Kenwin. So that was helpful. I didn't ask that earlier. I don't see any other questions from committee members or others. Whitney, do you have anything else to add? And before we move to the action portion?
No, I think the researchers did a great job.
Thank you. With that, we'll all accept a motion if somebody would like to make that motion.
I'll make the motion, Carol.
Oh, please, go ahead.
I move that the board approve the data sharing agreement requested by the United Way and West Ed.
Thank you very much. Any discussion to that motion, committee members? I see none. Let me repeat the motion that the committee approved, sorry, the data sharing agreement requested by the United Way and West Ed, and I'm assuming pass that on to the board for final approval. And Chair Brittany Cummins is going to correct me. Go ahead, Brittany.
No, my question was just in regard to the motion. In the conversation, the data sharing agreement was with West Ed only. Is that correct? And so should the motion state that this is a data sharing agreement with West Ed?
Yeah, I'm reading from something that says requested by the United Way, but it's probably for West Ed, or is that more accurate?
Yeah, I think that this was a little bit of a misnomer. West Ed and United Way together are requesting the data, but the data sharing agreement is just with West Ed.
Is that clarified enough for you, Vice Chair Cummins?
So I'm just thinking the motion should reflect what it is that we're approving, which is the data sharing agreement. So it should just state West Ed, not United Way.
Without objection, the motion, let me try again, that the board approved the data sharing agreement with West Ed. Is that okay with you, Lorianne, who made the motion?
Yes, thank you.
Okay, so that is the motion that the board approved the data sharing agreement with West Ed. Somehow United Way is involved, but not the receiver. With that, you can vote actually on this program. So you can go ahead and would committee members please vote yes or no on that. And I see Board Member Haynes, you're clear down there on my list. I see the voting's completed. It's unanimous and in the affirmative. So thank you, committee members. Thank you, Whitney. Thank you, all the others who participated.
Thank you so much, board members.
Chair Lear, before we move on, Board Member Haynes, could you just rename yourself and add your district number to the beginning of your name so you'll pop to the top of our list?
I am doing that right now. Thank you, Angie.
Perfecto. Thank you, Angie. I didn't know how to do that. We'll move on to an action item number 2, which is the Credo Stanford DSA Amendment number 2. And the people to talk about that are request for data. Again, Whitney Phillips.
Yes,
Data
Whitney
privacy
Phillips. Yes, Chief Privacy Officer. So Credo is an organization out of Stanford that we are currently working with and that have analyzed data primarily on our charter schools. They have all the data, but they would like to analyze the data in a different way. Our data sharing agreements are very clear that you can have data if you follow the rules, that you only use it for a particular purpose. And so Credo, wanting to use it for a different purpose, has come back and we've added this amendment. They're interested in looking at the differences in student achievement when a charter school is run by a management company versus an independent operator. Yes. And Dr. Han, I mixed him up, he's from Credo, is here to answer any questions or give you more background on that as well.
Can I just ask you right out of the box, do you have an opinion? I see that the USBE director, Jennifer Lambert, doesn't have an opinion either way. Do you have an opinion about the appropriateness of this request?
You've asked me that before, if I have an opinion on it, and I try to stay pretty neutral on my opinion, so I'm going to push back. But I think that they have the data already. They're willing to analyze it for us, and Credo's a well-respected organization that has come back to us to do more work. So I'm going to leave that up to the committee.
Okay, that's sort of helpful. Thank you, Whitney. Do other committee members have questions about this? I don't see any hands raised. I don't particularly have any questions. Would somebody like to make a motion? I'm also not seeing anyone willing to make a motion. There we go. Vice Chair Cummins, would you make that motion or something else?
Yeah, no, I move that we approve the amendment request by Credo.
And Committee Member Haynes, did you have something else or just?
No, I was just going to. Thank you, Chair.
Thank you. So the motion is that the committee approve the request from Credo and move that to the board for consideration. All in favor of that? Any further discussion? Any further discussion? And I see you're already voting, and I see it's unanimous, and so that request is approved, and that will go to the board. Thank you on that item. Moving to the next item, which is item 2.3. This is an action item, R277507. We discussed this last month. This was the discussion of the adjudicative proceedings. That is a new rule. And I think the person primarily in charge is it Michelle, or is Michelle Buse, AAG Buse, or is it Ben Rasmussen?
I think Ben's not able to be here right now. And so I asked if I would share for him. And I understand that you're unhappy with the way that I have handled things, but I hope that my explanation can make things a little bit better.
That's too harsh. Let me stop you, Michelle. That was too harsh. I had a reservation, not a you handled it. Thank you.
Well, I hope that my explanation will make it a little bit better. I think all of us have had things in our closet that we've seen there, and we know that it's just fine and it's not broken. And every time we open the closet, we see it sitting on the shelf, but we never use it. And we think, oh, that's good, and I'm going to use it someday, but I just haven't used it in a while, but I know I'm going to need it someday. And this rule was one of those things, and you open the closet and see it, and after a couple of years of not using it, you think, well, I'm going to go ahead and get rid of it because I'll never need it. And about a year ago, we repealed this rule when it came up for its 5-year review. And of course, as soon as we got rid of that thing in the closet, we needed it. And as soon as we got rid of this, over the past year, we have experienced a very active group in the legal community who have wanted to legally challenge many of the administrative decisions that the staff of USBE have made. And most of those decisions are decisions that do not fall under the Administrative Procedures Act and do not have a procedure set for appeal. And so we've kind of been stuck as to how do we address these individuals who have this attorney that wants to have these decisions relooked at. We even received another one this week. So they're very actively coming to us. When I met with the leadership of your committee, they found it helpful for me to explain a little bit about the Administrative Procedures Act. And so I want to just give you a 5-minute kind of preview of what that is. And it applies to any decision that any state agency makes that affects the rights of an individual. And it provides an administrative way for that individual to appeal that decision so that they don't have to go directly to court. And it gives them a more informal and hopefully less expensive way to be able to have their voice heard and have that decision reconsidered. And the Administrative Procedures Act provides 2 different ways for that to be done. It can be an informal hearing, which is the way that we most frequently do hearings in the education arena, or it can be a formal hearing, which is more like the UPAC hearings. Under the APA, the default is the formal hearing, unless the agency has in its rules that it will have an informal hearing as default. And in the past, our rule had that so that we could start out with the less expensive, less formal, less likely that the individual would have to have legal representation. They would feel more comfortable being able to present it themselves. And it could be something that wasn't as burdensome and maybe intimidating, that it was a little less intimidating of an environment for them to be able to have that reviewed. But the hearing officer could always change it if it was a more important decision or needed a higher level of due process. They could move it to be formal at any time. Once this decision is made, if the person doesn't like it, they can still take it to court and they can have a judge hear it. Well, it's a great thing, except for over the years, there has been a list that has grown and grown and grown of issues that don't fall within this Administrative Procedures Act. Currently, there are a group of 23 different areas of decisions that don't fall within it. And so many of the issues that have been brought by the legal community and the decisions that have been made by either the board or by staff fall within those. So we haven't known what to do. Issues about employment and licensing, those things are all handled either through negotiated agreements, through UPAC rules, or through DHRM, the Division of Human Resource Management rules. So these do not apply to things like employment decisions. The things that we intended this to apply to were those things that fell within the APA so that it designated them as beginning as informal, and then they would follow the APA after that. Or those that don't fall within the APA, it would provide the board a way to be able to have someone have it addressed without going to court first. So it gives the board that opportunity to be able to say to someone who's unhappy with a decision that happened, well, we could provide you this opportunity for a hearing here at the board level rather than going directly to a court. So that was our goal in putting this rule back to life and bringing it back to life. So we did work with some of the constituents of the public that had provided written input, and then met with one as well that helped provide some input. We tried not to make it too formal, to leave the board some leeway, because those that require a more formal process are already either in the rule or will need to defer to the Administrative Procedures Act themselves. So with that, I will turn it back to you as a committee to either ask questions, or if there are issues that you feel need to be modified in it, to propose amendments.
Thank you very much. Thanks for that explanation. And it struck home with me. I am a well-known hoarder of shoes and other closet items. So I very much appreciated your metaphor. With that, do committee members have any questions for AAG Buse?
Chair.
Go ahead.
Hands. People are raising hands. I'll back off. I didn't hear.
No, go ahead. Please, go ahead.
I was just curious. Are we really seeing a significant increase in these requests now? And previously, we went up to 5 years without seeing one single request. And if that's
actually, yes.
What's the difference? What happened? Can you identify anything that's changed?
An attorney who has found a prolific way to make money.
Oh.
I found some very smart arguments, and very he just has been very protective of some schools' rights, and has helped us to really look at the way that we do things. And he's been very active in the education community, and he's been just very protective of schools' rights and helped us look at things, and he's just very active.
Okay. Wow.
And don't you think, this is Chair Lear, I would add, just from my experience, committee member, that we also have a lot more, we've added a lot of complexity to the education system. We have now 120 plus different LEAs that are, that have issues. We have a lot of special programs that are expensive. So I think adding those to the complexity to the system, I think, has invited these kinds of questions and challenges. Other committee members, Member Davis.
Yes, thanks. I move that the committee approve R277-102 draft 4 on first reading and forward to the board for approval on second and final reading.
And thank you very much. Let me just, not to cut other people off, and we have 3 other hands. So if that's okay, Cindy, can we hold that motion? Thank you. So first, go ahead, Vice Chair Cummins.
Just a really quick question. When Michelle was describing the purpose and the intent of this rule, you'd mentioned that an informal hearing is a little bit less intimidating for someone going through this process and may not have legal representation. I'm just curious if they go through that kind of least restrictive environment type situation and find themselves maybe in a little bit over their head in the process, do they still, once they've gotten through that, have an opportunity to get legal counsel and have a more formal hearing opportunity? Or if they choose informal, is that kind of where they end up and court is their only option after that?
That's a good question. What happens is it's a different level of review in the court system. If it is informal in the administrative review for the Administrative Procedures Act, if it's informal, then the formal rules of evidence and discovery don't apply. And so the individual isn't seen as having had the extent of the ability to present their evidence and have everything heard as they are in the formal. So the appeal in the court system for an informal hearing is they appeal it to the district court, and it's like a whole new trial all over again. But if an individual has a formal hearing, they have the rules of evidence apply and they testify, and it's a higher level. of evidentiary procedures that apply. And so if they appeal in court, they appeal to the Court of Appeals. And so the outcome and where it goes afterwards, if it's informal versus formal, where they appeal is different. If it is not the Administrative Procedures Act that applies, they would be appealing the decision to district court, period. So if this rule were applying and it wasn't defaulting back to the Administrative Procedures Act, and it were a hearing that fell under this, it would be informal, and they would go to district court and have an opportunity to have an attorney with them and present all their evidence again.
Thank you.
Mm-hmm. Thank you. And then I see we have a hand, and I've got to interject at this point. I forgot the procedures that I actually supported previously, where we'd have a presentation and then we'd ask for public comment before the committee members got involved. I forgot that, but we do have at least one public comment. So we'll hear from AAG Quisenberry and then a public comment. Thank you. Brian?
Yeah, thank you. Good afternoon, everyone. I had a chance to review this again this morning with the lens of looking through it on behalf of USDB, which has a negotiated agreement, as you know. So I've raised a couple of issues or things to consider in my mind. One, and this is the easier of the two, the negotiated agreement gives a complainant 10 days to appeal to the board, whereas this rule allows for a 30-day appeal. And so on the face of it, there would be a conflict there, which raises the question, do we want to allow for deference to a policy or a negotiated agreement that has a different timing, appeal timing than the rule, or do we want the rule just to govern over any other conflicting policy or agreement? So that was my first thought I wanted to present. Carol, any sense on that, or Michelle?
Michelle,
if it's okay, if I can answer. Our intent was this would only apply where there wasn't already a procedure in place, and our hope was that USDB's negotiated agreement would apply in and of itself and would have its procedures in and of itself spelled out. So you see that this rule would need to be looked to from the negotiated agreement of USDB, or do you think that that USDB's negotiated agreement could handle its own proceedings?
Well,
let me just ask a clarifying question of both of you. Is your question, Michelle, which trumps? Does the negotiated agreement trump, or does this rule trump? Is that what you're questioning?
Yes, this would only need to be used for instances where there was not another procedure in place. This would only be used where there was not another procedure in place.
But it doesn't say that specifically, or does it?
No.
I need to back up.
And Brian, while we're finding if it does, did you have something to add?
Well, so it does refer to another line 29. So line 28, 29, 30, the board shall conduct all requests for a hearing as informal under UAPA unless another statute or rule specifically. So we could include there another statute, rule, or policy or negotiated agreement or something to that effect to make it clear that if the agency has already negotiated or prepared or created an appeal mechanism. So otherwise, it seemed like we might have some confusion. If a complainant doesn't like the procedures in the negotiated agreement, he or she might want this Rule 102, or vice versa. So thereby creating some confusion.
I apologize. We could interject on line 17 for board policy, because you are the board for USDB, so their policy would be your policy.
Yeah.
I'm not sure how that reads on 17. This rule does not apply to actions for which separate adjudicative procedures are specifically provided for in statute. Oh, I see. Or rule,
Yeah.
rule or board policy, capital B board.
Yes.
Yeah, I like that, Michelle.
We would have to put comma after statute, delete or, and then have rule, comma, or board policy.
Chair, may I make a comment? Sorry, I can't raise my hand because I'm one of the co-hosts. This is Angie Stallings. So this is just the purpose of the rule. So let me look and see where else it might be in the, I mean, I guess I wonder if this should be restated, and I need to look below and see if this is also restated in the body, because right now this is just the authority and purpose.
It's not restated in the body.
Okay, I would recommend that. So let's make the change though really quickly. So are specifically provided for in statute, rule, or, and what was the other thing you wanted to state?
Or board policy. I'm a little, and I'm sorry, we're just having a discussion. And I know two people have their hands raised, so I'm not ignoring you, Vice Chair Cummins and UEA General Counsel Tracy Watson. But my reservation about board policy is that this is a pretty weighty limitation on someone's rights. I'm not sure if that should be, if board policy should necessarily govern there. Do you have a strong opinion about that?
Are you referring to me?
Any attorney, there's three attorneys there that I can be asking that of. I feel like a board rule, I would definitely think that would address a person's, an individual's concern because of the formal process of rulemaking. I'm not so certain about policy, but I'm sincerely asking. I'm not saying.
Yeah, I think that's a fair point, Carol. I would just say with the negotiated agreement, of course, that's negotiated between both sides. They've had a chance to thoroughly review and agree to appeal procedures. So I'm not as hesitant with that worry about kind of the concern that you've just raised there.
But it's not one of those things. It's not law, rule, or board policy. A negotiated agreement is not that. Is not. How would you bootstrap that in?
Angie
Chair,
might have an idea.
Yeah, I agree. I don't know. I don't think that board policy is the right tool, because board policy would generally apply to, like you said, people, agencies that like USDB who are already under the purview of the board. I just cannot see USDB ever suing the board because they'd essentially be suing themselves. Negotiate agreement, I think were we trying to deal with probably something more between an agency like the state charter school, well, the state charter school board is not a separate agency, but so let's say a different entity that, and maybe that's where I think Brian's recommendation of negotiated agreement might be good.
Well, the context.
I'm sorry, Brian. Maybe it's just about employment actions.
Yeah. That's the context I'm thinking of. Is they had an employee that grieved a discipline, and it through the negotiated agreement, and so I guess and that's what's in my mind. I guess that's the context of this issue that I'm raising. And
I guess negotiated agreement is not necessarily a term of art, and it could be something that gives a much longer timeline and then trumps this 30-day timeline, which I'm not necessarily sure I'm comfortable with. Can you hold that thought, and maybe, I don't know if you can confer with each other, but let me hear what the other board members or committee members have to say, and then can we come back to that in a second while we think? Is that okay? And I think we have questions I now have questions from Brian. Your hand's still up.
Brittany, and I still have one more, but I'll get at the back of the line.
hold that thought. And then other committee members, I thought Cindy, no, I thought somebody had a hand up, but I don't see it now. So, oh, Cindy, yes, you do. Committee, Member Davis.
Well, I guess I was just going to ask for some clarification to your point. You're saying that this is severely limiting people's rights. I mean, does this preclude them from going straight to court? Is that what you're saying, or
Me?
Lose that right to go straight to court, and how?
No. What I meant. I'm sorry if you're asking me. Is that what you meant, Cindy?
Yes.
Oh, my concern is that when I say severely, I mean that if something, and maybe I overstated a bit or exaggerated, but if something limits someone's right to protection under a rule, if something an agency does or an entity does that limits a person's rights, it usually is done by statute, by law, or by rule, which has the effect of law. And I think it definitely, this is so much less expensive, less onerous than going to court, that I think it is a significant difference between being able to avail yourself of this procedure versus filing even in district court. So that's what
Carol, can I clarify my question? So
Sure.
you seeing this as a positive?
I'm seeing it as a
limiting. Was it the timeline?
No, I thought the limiting was the fact if this rule, not just the timeline, but if this rule apply, who it applies to should be appropriate. And I don't want to cut people out that we shouldn't cut out. I don't even know where to draw that line. I'm just saying that board policy shouldn't be able to limit people's rights because of the informality of passing a board policy. That's what I was trying to express. Does that help at all?
So do you feel if we pass this, we are limiting people's rights, or it's a helpful?
The whole rule? No, I think the whole rule is a good thing myself. I just want to be accurate or be appropriate in what would trump this this rule. I just want to get the right balance to the extent we can. And so that's all I was concerned about.
Okay, that helps me understand better. Thanks.
Tracy, let's hear from Tracy Watson from UEA, and then Brian will come back to you if that's okay. This is not the order I laid out in previous meetings, so I apologize. I'll try to have public comment earlier on going forward. But go ahead, Tracy.
So this is Tracy Watson from the Utah Education Association. First, I have to agree with Carol. I loved Michelle's analogy about the rule being in the closet, and then the minute we took it out of the closet, we needed it. So yeah, I think the rule, I think there's a definite need for the rule. I also want to express appreciation to Michelle and Brian and Ben for meeting with me in the interim from last meeting to this meeting. And so we went over a lot of this rule together. It's just seeing it in final draft 4. I had some concepts I wanted to bring to the board's attention. So first on line 37, and it kind of goes along with what Brian was talking about in terms of whether it's 10 days or 30 days. You know, if you're seeking an appeal before the Department of Workforce Services, they have a 30-day timeline, but they have an exception for good cause, right? And so I wonder if you want to consider, you know, having a 30-day timeline, but how strict you want to be on that 30-day timeline. If there was a, you know, I needed an attorney, or I didn't find this rule until then, or I didn't know about this. So just something for the committee to consider. Moving to line 49 and 50, it says the presiding officer shall establish timelines for the hearing and shall determine if a hearing is open or closed to the public. Kind of curious how that determination would be made. It's not clear to me. Then into section 5 on lines 72 and 73. This is a little bit different than what I thought Michelle explained. So if it's a formal adjudicative proceeding under section 5, 72 and 73 still say that the presiding officer is not bound by the rules of evidence or the rules of civil procedure. So I'm not sure how that would affect, if they're not bound by those in a formal proceeding, I'm not sure how that would affect the ability to go to a district court or an appellate court. So maybe Michelle can give us some clarification on that. And then lastly, lines kind of around 85, I say around because it's a concept. So there's a written report that the parties are going to get a copy of, and then it's going to be presented to the board for the board's final consideration. And the board has options. They can approve the recommendation or they can issue an alternative written determination. So I wonder if we want to have a period of time where either party could appeal to the board, not appeal as in a whole nother hearing, but could do a brief or something to the board if they disagreed with the hearing officer, so the board would be able to consider that in making its determination, or if the agency, as in, whoever's representing USBE, didn't particularly agree with the hearing recommendation, that they could do that too. So again, these are concepts for the committee to consider before finalizing the rule. Thank you.
And thank you for those comments. Michelle, would you like to respond to that?
Yes. Let me just see if I can unmute myself. Oh, I'll just hold the button.
You are. You're great.
Let me go backwards on it. As to that final one of appealing the hearing recommendation to the board is the one who takes the recommendation and makes the decision. It's not the hearing recommendation that is the decision. The recommendation goes to the board and the board decides whether to accept the recommendation or not. So you would be appealing to the same body that makes the decision itself. So I'm not sure that would be, that would sort of be futile, because you would be appealing to the same body that made the decision in the first place. The recommendation is just a recommendation, and it's generally would be by a panel of the board, and then goes to the full board to determine whether or not to accept that. So that one I'm not sure about. You asked a question about lines 71 through 73 and felt that was confusing as to whether or not it would be go to district court or court of appeals. I stated earlier that the determination of whether it would go to the appeals court or whether it would go to district court only applies to those issues that actually default back to the Administrative Procedures Act, but that anything that went under this rule would go to the district court, would be treated as informal. So things that ended up going under this rule completely would be considered informal because those rules would apply.
I'm sorry, Michelle, can you clarify that? Because the title of that section is Procedures for Formal Adjudicated Proceedings. So it would still be deemed to be informal?
Yeah, under this, it's more formal, but it's not as formal as the Administrative Procedures Act formal proceeding. It's more formal than a traditional informal proceeding.
Okay, thank you.
Yeah, but
I have a question.
Go ahead.
I think that's what Ben and I were working through, that it's not as high a level as the Administrative Procedures Act calls for.
Would it be helpful, Michelle, just on this one, say in ruling on matters raised by the parties through an informal, like we could put informal here, because it looks like above, this is the formal, right? You are conducting the proceedings in accordance with the Administrative Procedures Act, right? Would it, in your mind, does this only apply to informal? Because we could just make that clear and just say in ruling on informal or matters raised by parties. And no?
I'm concerned that you may be using formal as both a term of art and sort of in a more general way, and it's a little confusing to me. When you say not as formal as specifically under UAPA, but more formal than informal, that to me uses the terms two ways. I'm just wondering, and
I think that language comes right out of the rule, the law. The law itself says in the formal procedures that you're not bound by the Utah rules of evidence. I will find that in the law. I think that language comes right out of the formal.
I'm wondering, this is a general question for committee members and per Member Davis's motion. Cindy, why don't you speak? And then maybe I'll wonder in a minute. Go ahead. And Brian had another question, another point to make too.
Well, no, I guess I was going to ask, are you going to suggest postponing another month on this, or are you?
That's what I was thinking, maybe. I think it's important enough to get it right. And it seems like there's more to consider, but I also don't know. I know that Michelle had some desire to get something in place because these requests continue to come in. As she said, almost, not daily, but on a regular basis. They're not stopping.
Can we hear from them? Is it possible to fine tune some of these things and come back in a month, or is there a time sensitivity right now?
Thanks for that question. Michelle?
Things that have already come before the board need to be handled based on the procedures that are in place when we received them. So I think that you have time to delay it and you have time to get it right, as Chair Lear said, so it doesn't impact the.
Thank you. Cindy, does that help?
Yes, I'll withdraw my motion.
And Brian A.G. Quisenberry, with that comment, do you think you can wait on your other concern about the rule?
Well, it would be helpful to get a little guidance as to how then
go ahead.
So here's my second question. This is a little more conceptual. Basically, the rule divides procedures into formal and informal. Formal, I view a formal proceeding as basically a mini trial with witnesses, evidence, cross-examination, and so it's a mini trial. Informal, that begs the question of what exactly is informal, an informal procedure. If you look on line 39 through 41 is the best description I could find here of what an informal is going to look like. So it says 39, the agency head may designate a hearing panel consisting of a presiding officer and board members. Here it is, to hear the evidence and make recommendations to the full board. That's basically the description of the informal. It's to hear evidence and make recommendations. In my mind, that begs the question, what does it mean to hear evidence? Does that mean witnesses, cross-examination? Or does that mean submission on briefs and no witnesses? And so if it means witnesses, then it's awfully similar in my mind to a formal. My thinking, my recommendation is to make that more informal in the sense of a briefing. They hear evidence from briefs or written submissions and make recommendations to the full board. So that's one way. And this specifically came up in a employee dispute with USDB, where the employee wanted a full-blown mini trial. But the procedures governing that weren't real specific. And so we had a bit of a dispute over whether it's going to be written submissions, like briefs, or if it's going to be a full-blown witnesses on the stand under oath. So conceptually, what is the committee interested in terms of an informal proceeding?
Member Davis? Cindy?
So I would suggest kind of going back to the table a little bit and working on some definitions. I think that if we probably should include a definition in this that shows that it's a very different procedure than the more formal procedure, and that could be outlined in this, and perhaps it's done through briefs rather than witnesses and what have you. I also would like, if we go back, I would like to have us look at some language on line 37 about an exception for good cause, similar to what Department of Workforce Service does. I have had too many, even in just my short years here, people say, have problems with timelines. And by the time, people just don't sit at home watching what we do, and they feel like it takes time sometimes for it to, all the pieces to get to the point where they realize they even need to appeal something. So without objection from the rest of the board, I would like to see something like that considered as well.
Thank you. I would like to at least have it discussed. Member Haynes, would you like to add to this discussion?
I've kind of got another question that could be off topic a little bit. Is that okay, Chair?
Sure.
It's directed to AG Michelle Buse. If you could help me understand, last month a decision was made to keep Paradigm in a turnaround decision, or not allow them to come out of turnaround. Would what we're talking about here today impact that decision?
No, because they have well, I will say this rule would not be in effect in the time frame for them to appeal under this rule.
Okay.
You made your final agency action, so if they were to appeal that, they would need to do it under the time frame of the Administrative Procedures Act, which is the 30 days.
But if you're asking,
won't be the what will govern it.
Yeah, they were asking
your
about
rule today.
If there was an opportunity to appeal that last month, and based on some information that I provided them, there really wasn't. So I wondered if that was even.
But are you asking conceptually, Mike, or are you asking that specific issue?
Yeah, something like that. Would a decision like that be
conceptually?
Yeah.
Appealable.
It depends on whether it's something that is exempt from the Administrative Procedures Act.
Okay.
So we'd have to look at the exact issue and see if that exact issue was exempt under the 23 exemptions of the Administrative Procedures Act.
Okay, that's great.
Thank you. Member Davis, did you have another thought? Cindy, no?
No, I think if everybody, unless people have more concerns to bring up, I think we don't need to make a motion to have this go back a month.
No,
right?
I agreed. Agreed. Without objection, and Mike, is your hand up continuing for another comment or question, or you just didn't take it down? There you go. Let me just add one thought I'd had. I would hope we could look for some middle ground between only deciding based on briefs and versus no witnesses, no procedures. I have, maybe just because I've had a lot of experience with the UPAC process, I find some fact finding and hearing from witnesses with very limited discovery helpful and more satisfactory as a board member. So that's just to throw into the mix of what you want to discuss. Without objection, though, unless anybody has further comments, other committee members, we will ask Michelle and those she's been working with to continue to refine this and consider some of the comments made by board members and bring us back something in the next month or two. Is that all right? Just by general consensus, which is a redundancy. Sorry about that. I don't see any objections from committee members. So with that, we will leave this fascinating topic. Thank you. Thanks, Michelle, for all your work. Thank you also for those who participated and offered comments, including also AAG Quisenberry. Thank you. With that, we will move on to item number 2.4, action item R2777-100, a definition. And I think the designated question answer is Rhett Larson. Is that right, Angie?
Sorry, Jeff, would you he may want to give an overview before turning the time to Rhett and Christy for any.
Great.
Yeah.
Then designated Jeff Van Holten.
Great. Can you hear me?
Perfect.
I don't know if you can see me.
Cute hoodie. Yes, we can see you. Or bathrobe.
Oh, there I am. I'm like, I couldn't see myself. Okay, yes. So I'm going to pass this over to Rhett very quickly. But just to give you a highlight, we're adding 2 more definitions to the board rule that defines terms for all of the board rules. The reason why we are doing this is kind of a precursor to some things that will be seen most likely in the Standards and Assessment Committee, but they could come here as well, where we're going to take Rule 400, which is a rule, kind of the, I don't know if Rhett will appreciate me saying this, but it's become the safety Frankenstein rule in a way. It's a rule where anything safety related we kind of stuffed, including drills, fire code, all sorts of things. And there is a desire to kind of split that out and actually have a whole section of safety rules that are much easier to navigate than Rule 400. In efforts and first steps in making that happen, we are adding in these 2 definitions of a threat and threat assessment. As you may recall, you, as a board, passed CSTAG as the threat assessment framework for the board to use and the School Safety Center to use. And CSTAG has some common definitions for these larger terms that get used very broadly. So we wanted to adopt the same language that CSTAG uses for these terms so that as we do our trainings and we make rules, that LEAs understand and have a common language regarding all of the efforts that are going on in school safety. So that's kind of what you have before you today, and I'll pass it over to Rhett for all the things I forgot to say.
And just
Rhett,
as a clarifying question right at the start, I'm seeing, I'm hoping we're all looking at draft 2. Is that right? I don't see the red and blue in your
We
draft.
can. That is a board member Earl amendment. And did you want to just go ahead and assign that before a motion's made? That's
let's hear from Rhett. Let's hear from Rhett first, and then let board member Earl speak to her amendment. So Rhett first.
Absolutely. Thank you, Chair. So Rhett Larson, School and Student Safety Specialist. So as Jeff mentioned, with the movement, with moving into more of a, or bringing our school safety program more to light in Utah after House Bill 120, but also recommendations from the Federal Commission on School Safety on implementing threat assessments into schools. We did present to you, and you approved the comprehensive school threat assessment guidelines as the evidence-based threat assessment procedures to use in the state of Utah. And as we are going about doing trainings, and as we refer to terms, the terms threat and threat assessment, we thought it would be great to have the definitions here in R277100. These are the exact definitions that are used in the evidence-based guidelines. We just used it because we thought it'd be great to have the same language across. We did work with board member Earl yesterday on her recommendations, and I think her recommendations are fine as it further clarifies some of the work there. And so we are happy with that as well. There has been some additional communications back and forth as the School Safety Center met. In that definition, there's some concerns with the words, sorry, my mind just left me, with the words violent act. And so I can continue to speak about one or speak to changes or have a conversation with the second draft, whatever you want me to do there, Chair.
Let's let Member Earl speak to her amendment first, and then you can speak to the differences and how much it matters. And there might be other board members with questions too. So, Jenny, would you like to speak to why you prefer your draft or definition to the one that's proposed?
Yeah, so I just felt like there needed to be just a little bit more detail in this particular definition. And I did there were two recommendations, and I did look at those, and those are implemented into this draft here, just so that you know, both the prevention and then the including was the section there. But I just felt like the definition we had before, a problem-solving approach, to me almost needed another definition to know what a problem-solving approach all entailed. I just felt like this was a little bit more detailed as far as what we're looking at. It still includes prevention strategy. It includes, I think, the components up above, but it broadens it out just a little bit so we get it kind of a hand, or we know exactly what we're measuring. So anyways, so if you move this amendment, then I would just encourage you to apply this definition. The other thing is, I asked Rhett, I wanted to make sure there weren't any complications with putting this new definition in or expanding it a little bit with with the CSTAG program that we'll be using. And it sounded like there weren't, and maybe Rhett can speak more to that this would coincide enough that it's not going to create any problems that way. So,
and let me, before we let Rhett answer that, can I just ask you, I don't know that you gave this answer expressly in your explanation. What do you like better about this than the definition that was proposed?
Well, I did hit on that a little bit, but the problem-solving approach to me means a problem-solving approach. I almost feel like we need another definition to define what a problem-solving approach is, so that we know exactly what that is. So this down here, the blue prevention strategy, and it just specifically, it includes these elements to it. So it breaks it down enough that you could look at identifying student threats, including to commit violent harm, determining the seriousness of it, developing intervention plans that protect potential victims, as well as addressing underlying problems or conflicts that stimulate the threat behavior. I just think it's more clear as to what that definition is.
Thank you. That's question, and I've heard that before. Yes.
Okay.
That's really helpful. Thank you. Let me see if others have questions. Member Cummins.
Thank you. Sorry, takes me a minute to find my mute button. So my question initiated when I read the first definition that was provided in draft 1, where it talks about the threat assessment definition, and it says intervention with students who have threatened violence in some way. And so I guess my question is the context of where this definition will be used. Are threat assessments not applicable for this definition when the threat is coming from the outside? So it's not a student who might be threatening violence, but some other source of threat. And so because this definition seems to be very specific to a student who may be initiating violence in a school setting. So I'm just curious about the context of when this definition would be used, because I don't think the proposed amended clarifies that for me either. So
it's still student. Yeah, Rhett, I'm sorry. Rhett, I think you'd be best to answer that.
Thank you, Chair. And thank you, Board Member Cummins and Board Member Earl. To go back to Board Member Earl's comment, I think what she's proposing really does help clarify as to the work, and I do think it's a great recommendation there. And to go to Board Member Cummins' comment there, when we look at the term or the idea of zero tolerance policies, we looked at where there's students who are being penalized or that they're being, a variety of disciplinary actions for all different types of threats. So to give an example, a student who in Florida chewed out a Pop-Tart to the image of a gun and then was suspended under zero tolerance policies. So we really wanted to look at what is a better way to look at threats that are made and to determine whether they are non-serious or very serious. And in CSTAG, those are called transient and substantive threats. And so really, this is a great resource and guide for LEAs to use within multidisciplinary teams to look at threats that are made by students to determine the seriousness of those threats, what interventions could be in place to keep those students safe, but also to help the student who has posed a threat or in very serious threats, what actions need to be taken. And so really it is guidelines and for the umbrella of students making threats. I hope I answered that question for you.
And let me just ask, let me try to clarify, Brittany, but if I don't get it, what I think you were asking, then please step in. You maybe the very last comment answered the question, but I thought I heard Member Cummins asking if this was limited to student threats. It wouldn't be volunteers or employees or even non-students who happen to be on campus or involved. Is that what was intended, to limit it to only student threats, or was that just what the general problem is?
And can I add to that clarifying question as well?
Yes.
Because this is in Rule 100, which is kind of that general definitions rule, is there other rules where we use the term threat assessment in a non-student way where this would conflict? And so, so in addition to what Board Member Lear just said.
Rhett, again, hot seat.
Chair, thank you. So really, this, when we're talking about the threat and threat assessment as it relates to these definitions, it really is speaking to the CSTAG guidelines, which is surrounding that piece around students making threats in the school building or towards students. And so I can't think of anything within board rule where we talk about threat or threat assessment in any way where it would conflict there. I certainly think that's some work that we could look into as far as other threats that are made, but this is speaking specifically just to students and that threat assessment piece. And so that would be my answer there. And I'll lean on Jeff a little bit if he thinks it would conflict in any other way outside of that student threat. I'm not quite sure. And my apologies there, Board Member Cummins.
Chair Bear, I could respond as well, if I may.
You were kind of breaking up a little bit. Jeff, did you want to add to that?
Yes. So in terms of does it currently conflict in the way that it's being used in any of our other board rules? And the answer is no.
Having a problem, try.
Oh, can you hear me now? Am I breaking up?
Yeah, still kind of, you go in and out of a tin can, but go ahead. Maybe it's my iPad. Go ahead.
So I was just mentioning that it's not currently used outside of a student lens in other board rules at all at this point. I do think that is a good point, Vice Chair Cummins, that we need to keep in mind that as we move forward in using that phrase, that it's very student-centered, or we may need to be updating this in the future. But typically, and Brett, you'll have to correct me if I'm wrong, usually in the school safety world, we have not encountered threat or threat assessment in particular to really be geared toward outside threats. It's always assessing the threat that a student can pose to self or others. And really, if I'm understanding CSTAG correctly, that's really the lens that is used in terms of versus, assessing threats against a school that could be posed by any member of the public. And we really have not used threat assessment heavily until now. Really not until House Bill 120 of the 2019 session have we really started to incorporate threat assessment and the phrase and the terminology into more of what we use and our communications with the LEAs. So we're still kind of on the beginning side of developing this language and the common understanding. So another big reason why we want to make sure we get it very clear, the lens that we're using it for in this particular setting. So great question. Thank you.
Chair, can I make another comment?
Sure, please.
So the threat assessment itself, now like the Secret Service and FBI, they have their own threat assessment and threat assessment procedures. And they've worked with Dr. Dewey Cornell, or I should say Dr. Dewey Cornell has worked with them. And so they have their own procedures and process that would be obviously outside of the lens of the student. But Dr. Dewey Cornell, as he created the CSTAG guidelines for schools, that's where he used these definitions for threat and threat assessment within this model as it relates to students. And so this is a piece of an overall larger thing, or I guess it kind of models in a way of what Secret Service and FBI uses, but that's a totally different arena. But I just wanted to make sure I highlighted that work as well in that piece. But as it relates to the work that we will be using and moving forward, it's more relating to the student section. Thank you.
Brittany, do you want to respond to that?
Yeah, just one last, I guess, follow-up question or concern that I have is the term threat assessment is a fairly common term, and I think currently schools are being required to look at overall school safety plans, and would this definition that we're putting in this board rule, and I know it has a specific purpose now that I understand the context, but as we're trying to define this term, will it cause any problems as student or LEAs are trying to use words and verbiage within their school safety policies, their overarching policies, where they assess a threat, and how do they react to certain outside threats, internal threats, et cetera. And so I'm just a tad bit concerned that we're using a very general term that can be used in many settings and putting a very restricted definition for it in our overarching definitions rule, and not just in the rule where this would be used in a more specific term, as a more specific term.
So, and just to make sure I'm hearing what you're saying, do you feel strongly enough about this that you would like to take out the word student or broaden it, or are you just saying that that's a caution as we go forward?
Maybe what I'm saying is, would this definition be most appropriate in the rule that it applies to in this specific manner, not in our general definitions rule? And maybe Angie could speak to like its placement because it's anyways, and so its impact on our general place. And if we have a school safety rule that's just talking about school safety in general, and we talk about assessing threats, in that general sense, would this term be best defined within the rule that it's being very specific toward?
And I think that's a good question. And I want to go to Jeff or Angie to answer that. Let me just add one more sort of aspect of that. I keep thinking of these, the school shooters who come onto campus who've often been former students or dropouts, or and yet a threat assessment, maybe there's no way the system can make a threat assessment on those people if they're dropouts or former students. But it seems to me that we'd want to broaden it a little bit, but I also am not the expert that Jeff and Rhett are. So
Carol,
factor that in. Yes, go ahead.
Can I just add my voice to Brittany's? I had the same concern, but I really think, since this is a general definition, that we should take out the word student. And if this needs to come in a formal motion, I'm just wondering if we can get feedback on this. So it would just read identifying threats, including to commit a violent act, and then it does say developing intervention plans that protect potential victims and address the underlying problem or conflict that stimulated the threatening behavior. And while you could say that would only be specific to students threatening other students, perhaps not. Perhaps an underlying problem is that every door in the building is open all the time, or perhaps an underlying problem is that there's a prevalence of mental illness in the community. But I do think you wouldn't take anything away from this by just removing the word student and just leaving it to identifying threats, or you could say identifying threats to students, including to commit a violent act.
I agree. And maybe we'd like a response from, again, going back to Jeff or Angie or Rhett, whichever one of you is most appropriate.
I'll jump in quickly.
Go ahead.
And Brett, you let me know how you feel about this, as we're all kind of thinking out loud. One thought that I have is, and I'm getting this from Christy Walker as well, where she and I have been texting a little bit about this idea. Maybe we refine this to say student threat assessment, mostly because if we change that term, we could then have a broader threat assessment once the school safety center is ready to get into that. The CSTAG, and this is where I'm going to rely on Rhett, it's very specific to student-based threats. And so while we're going in that direction, I'm not sure that the school safety center has reached a position where they want to start getting into the broader threat assessment and the community at large around the school outside of the student. So this is definitely where we're starting as a school safety center. So I don't know if that appeases others, and Rhett and Christy, if I've misspoken and misrepresented, please correct me.
Thank you.
That's an offering, though.
Would you like to add to that, Rhett or Angie?
Sure, I can, and hopefully I didn't speak before Angie. Angie, if so, just let me know, and I'll let you go first for sure. I like that idea of adding student before threat assessment. I think that would really help us get to that, and also speak to the work of the CSTAG itself, which is the Comprehensive School Threat Assessment Guidelines. And so I think by putting the student in front of threat assessment would be great. And then also to help clarify and answer your question, Chair Lear, threat assessment is for students who have made a threat in a situation where you're talking about a student who might go into a building with a gun. That would be more of crisis response. And threat assessment, so crisis response is not prevention, where threat assessment is. And so that there'd be two different things there.
Thank you. Thanks for that helpful information. I learned something. Thank you.
Could you repeat that last sentence?
Go ahead, Rhett.
You bet. So threat assessment is for that is in the prevention arena, as far as looking at, okay, a student has posed a threat. Is the threat serious? Is it not serious or very serious? And really having the team look at, what do we need to do in this circumstance? What interventions need to be tried out? If a student were to walk into a building with a gun, that would be more of a crisis response situation, where obviously crisis response is not prevention. We would be acting in the scenario that took place at that time.
Thanks, Rhett. So anything else to add in terms of adding?
Can I add one thing, Chair?
Go ahead. Yes, please.
Board Member Cummins asked whether or not this rule was applicable or appropriate to be put in the general 100 rule, or if it should be in a specific, its own rule related to the program. My understanding is that we anticipate this term being used in a couple of rules, and that is why they wanted to have this defined term in one place in 100, so that you wouldn't somehow have people inadvertently amending it in one rule and not realizing it's also in the other rule. And I think that if we change the term to student threat assessment, I think you're less likely to have the issue that Board Member Cummins raised, which is, what if they're just talking about assessing a threat somehow in another rule? This is a true, I think student threat assessment would be
the term of art
or phrase. And so if somebody were to say assessing a threat in another rule, this definition wouldn't apply to that. But you're right, there's always pros and cons about deciding whether to put a defined term in 100 or to put it in the individual rule. Because in this case, I think it was a proactive decision by staff to put it in 100 so that you'd have a uniform term throughout all of our rules for that, versus having it in a couple of different, and again, you have amending issues where you might amend it in one place and not catch it in another.
Member Cummins, does that address your concern if it were changed to student threat assessment?
Yes, thank you. I think that definitely, yes, thank you.
And I like that better also. Can we, without objection, change that to student threat assessment on line 196? And Jenny Earl, if you're still online participating, does that suit you as well?
Perfect. I think it's perfect, Carol. It does get to the heart of what the definition means, right? And making sure we're very specific about it. So
Thank you. So without objection, that would be the only change. Is there any reason, Angie, we have to vote on that if we all collaboratively and cooperatively agree that student threat assessment is the better term to define?
I think you're fine as long as you just, when you make the motion, just say draft 2 as amended. And we'll assume the amendment is adding the word student on line 196.
Student threat assessment. Okay. With that, I think we are, I see no fewer. No, I have one more hand. Member Davis.
I'll go ahead and make the amended motion, but and I don't want to belabor this anymore, but I think when you change it to student threat assessment, it's still, it doesn't fix the problem that we were trying to talk about, because we still have, this is in a list of general definitions, and we still have a need to define threat assessment, and we don't want to inadvertently leave out the responsibility that LEAs have working with their local authorities to go through some of these same processes for general threat assessments to students, which are also student threat assessments. So I'm just going to leave it at that, and someone can maybe tackle that on another day, and I'll go ahead and I move that that the committee approve R277100 draft 2 as amended on first reading and forward to the board for approval on second and final reading.
Any discussion to that motion? I'll repeat it. The motion is that the committee approve R277-100 draft 2 as amended, forward to the board for approval on second and final reading. Any further discussion to that? All in favor, committee members, please vote. Or not all in favor, all committee members, please vote. And I think there she is. Okay, that vote is complete and unanimous. Thank you very much for the discussion. Thank you, Rhett, Jeff, Angie, for your helpful comments and your participation. And we'll keep working on that ongoing broad enough to broad issue. The next action item is item 2.5, R277-311, specialized endorsements. It's a new rule, and I will turn to, I have listed Jody Parker, Malia Height, Audra, and Angie. I'm not sure who's the primary presenter.
I can start, Chair Lear, and then we can turn it over to staff just to give you an overview of this rule. And you'll see that the next agenda item is a repeal of R277507. So this R277311 will replace 507, and it includes 2 specialized endorsements. One is the driver education endorsement, and then second, you'll see, is the physical education endorsement. So the staff that we've got here with us are Malia Height, who is our coordinator for licensing, and then we've got Audra Yuri, who oversees driver education, and Jody Parker, who oversees physical education. So board members, if you have questions, any of the four of us would be happy to answer them.
And with that,
I was going to mention, you may want to just give either Audra or Jody just time to proactively maybe say a couple of things about what's in here that for your
whoever, whichever one of you would be appropriate, please. Jody?
And maybe I volunteered them and they didn't want to be volunteered. So.
I'm here if you have questions about any of that. I am here with my little bird. We're here.
Okay, you don't have anything to add. Oh, hi guys. As introduction, you don't have anything to add though.
I don't have anything to add. If you have questions, I'm happy to answer them.
Right. Okay, thanks, Jody. Malia, do you have anything to add? Or Audra? Okay, I'll take that silent. Audra would what?
Audra would be able to speak to the driver ed portion, but this is in response to things that exist in legislation.
Oh, thank you. I'm not seeing anybody jumping to speak. So board members, committee members, do you have any questions for any of these on these issues? Looking for hands, not seeing a hand. Would someone like to make a motion? Still not seeing.
I'll make a motion.
Please, go ahead, Lorianne.
I recommend, or I move that the committee approve R277-311, draft 1, on first reading and forward to the board for approval on second and final reading.
Any discussion to that motion? To repeat the motion, I don't see any discussion still. To repeat the motion is that the committee approve R277-11 on first reading and pass on to the board for second and final reading. Committee members, please vote. And I see that the vote is complete and it is unanimous. Thank you for that. Thank you for your participation. Malia, Audra, Angie. I missed somebody. Oh, Jody, thank you. The next action item was mentioned, R27, it's item 2.6. It's an action item on R277-507. You pretty much spoke to that, Angie. Anything to add?
No, it's just if we pass 311, we would like to repeal 507.
We don't need this.
Right.
So I'll entertain a motion on that from any committee member. Cindy, Member Davis.
Sure. I move that the committee repeal R277-507 on first reading and recommend the board repeal the rule on second and final reading.
Any committee discussion to that motion? I see none. The motion is to repeat that the committee recommend that, or the committee moves that we repeal R277-1311 on first reading and recommend to the board for second and final action
It's
to
507.
repeal.
Sorry, board member Larry, you said 311, but it's 507.
I'm so sorry. Let me try that again. So to repeat the motion correctly, it is to for the committee to recommend that for the committee to repeal R277-507 driver education endorsement and recommend to the board to repeal on second and final reading. All in favor, board members, committee members, please vote. And I'm seeing all voting affirmatively. That is a unanimous action. Cindy, I missed your hand. Did you have an additional comment? Or was that just a holdover?
No.
Thank you. That must have been. That is our final. We've had the authorization request from Snow College postponed at Snow College's request, so we won't be discussing it today. Thanks for many of you who've been working on this, and we will return to that discussion in a month or so, whenever is appropriate. So with that, thank you all for your participation and your thoughtful comments, and to staff also. And our meeting's adjourned.
Thank you, Chair Lear. Thank you, staff.
Thank you.
Thank you. Have a good day.
Thanks, Angie.